Item number 3, that criminal reference that regarding third seat was submitted by incompetent person in Nagaland. I want some time. When it be accomplished for 1 week?
Is this tied up matter before this bench?
It's a division bench. Not tied up, it's a division bench.
All right, you have informed the government advocate.
By Nagaland Island.
Mr. T.J. Mahanta, Lanet Senior Counsel, appearing in this case as
No, that's he assist me as a counsel of the advocate Guwahati.
as a counsel for the Guwahati High Court, seeks adjournment in the matter by expressing personal difficulty today. Full stop. Since the prayer is not opposed by Ms. T. Crow, Lanet Additional AG, Government of Nagaland, the prayer stands allowed. Registry to list this matter again after 2 weeks.
Well, must be
Hearing. Yes.
Milord, I with apology, Milord. Item 2, Milord, can I have some time, Milord? I two prayer before your lordship for
Why?
adjournment for today. And the second prayer is, Milord, I once want to meet the accused in the jail for some instruction, Milord. The case looks like a very simple case, but yesterday, last night, when I was reading it, some points are there which I wanted to.
Then you wait, let the matter be called up, then we'll see what order can be passed on that.
On the
Mention that order cannot be passed. Mentioning time, we cannot pass an order asking anybody to allow you to meet the accused. That's not possible.
Right.
Let the matter be called up, then we'll see.
May I please your lordship? Your lordship, item number 6. I'm appearing on behalf of learned counsel A.H. Laskar. Due to some emergency, he had to leave for Silsar. Kindly fix the matter for next Tuesday.
No, fix we can't. We can only adjourn.
Okay,
Fixing is,
but he is not available today at present.
a prayer for adjournment has been made in this case on the ground that the appellant's counsel, Mr. Muhammad A.H. Laskar, is out of station. Full stop. Since this is a criminal appeal preferred against the judgment and order of conviction, in the absence of the counsel for the appellant, this matter cannot be taken up for final hearing and disposal. In view of the above, on the request of the appellant's counsel, hearing of this appeal stands adjourned for 2 weeks. List accordingly. Yes.
May I appeal? So I'd like to mention regarding item number 4 and 5.
Hmm.
Item number 4 is appeal against conviction. There I am appearing. In item number 5, Lordship, I am appearing for respondent number 2 and 5. This is against acquittal of the other accused persons. I have received the instruction to appear on behalf of other accused persons also. And since I have not filed a wakalatam on their behalf, so this may be adjourned. I will in the meantime I will file wakalatam on their behalf.
Who is for the appellant in item 5?
M.K. Kolita, I have informed him. He was there.
Appeal against acquittal must have been preferred by the state.
Victim preferred.
Or victim.
Victim has preferred.
You take down Mr. A. Ahmed, learned counsel for the appellant appearing, learned counsel appearing for the appellant in item 4. Give the case number. Submits that in the connected matter, that is item 5, which is an appeal against acquittal referred by the victim. He has instructions to appear on behalf of all the respondents and not only respondent numbers 2 and 5. Full stop. Giving an undertaking to this court that within 2 weeks from today, wakalatnama on behalf of the other respondents, stroke accused persons shall be placed on record. Mr. Ahmed seeks posting of this matter for hearing again after 3 weeks. Full stop. Some of the accused have been acquitted, is it?
8 persons were acquitted, 1 person is convicted. In item number 4, he is convicted.
Stop. Taking note of the prayer made by Mr. Ahmed, we adjourn the hearing of these 2 appeals for 3 weeks. Registry to list these cases accordingly. Yes.
Okay.
Supplementary date for withdrawal item 7.
May I please, Your Lordship? I have instruction to withdraw this petition.
You have instructions to withdraw the appeal.
Appeal. This is an appeal against rejection of my bail prayer, madam. Similarly situated, they have been granted.
Have got bail in the court below. We want to try.
You want to try before the court below. Mr. B. Prasad, learned counsel for the appellant, submits that this is an appeal against an order passed by the learned trial court rejecting the bail application filed by the appellant. Full stop. However, appellants. However, in the meantime, the learned court below has granted bail
To similarly situated.
to similarly situated accused persons, and therefore he seeks leave of this court to withdraw this appeal so as to prefer appropriate application seeking bail before the learned trial court. Full stop. Mr. R.K. Dev Chaudhary, learned DSGI, appearing on behalf of the respondent is present and does not have any objection if the prayer is allowed. In view of the above, and on the request of the appellant's counsel, this criminal appeal stands disposed of on. Can it be withdrawn like this? Criminal appeal disposed of as not pressed with liberty as prayed for.
Since it is against bail, rejection of bail.
It can be. All right.
Bail list for hearing item 1.
May I please, Your Lordship?
Yes.
This is jail appeal against conviction under section 302 for life imprisonment. FIR, Your Lordship will find at page 4.
You come again if we call you. Come again if we call you.
FIR, Your Lordship will find page 4.
Yes.
Lost by the sister-in-law of the appellant.
Yes.
Humble submission is that around 8 p.m. on 21/5/2018, Monday, my husband Dharmen Dole engaged in an altercation with his younger brother, Sri Kumalenu Kalamanu Dole, in connection with a domestic matter. As a result of which, Kalamanu hacked the right hand of Dharmen Dole with a dao on the spot. Although Dharmen Dole was taken to Dhukuakhana Hospital, but around 12 a.m. he breathed his last. I therefore request you kindly to take necessary action and oblige. Thereafter, he was taken into custody. He was arrested from Zonai, and as it appeared from the paperwork, Lordship, he was in custody since then. He is in custody since then.
Since then means since when?
Since after 4 or 5 days of the incident, he was arrested, Lordship.
The incident took place on 21st of May 2018.
Lordship. As per deposition of the IO, he was arrested on 25/5/2018.
Yes.
And PW1, page 9, Lordship, is deposition. PW9 is the wife of the deceased and sister-in-law of the appellant.
PW 9 or 1?
PW1, page 9,
Yes. PW 1 is the wife of the deceased.
wife of the deceased.
Yes.
I know the accused person. He is the own younger brother of my late husband. Incident took place around 4 or 5 months ago. At that time, I was at my house. with my deceased husband and we were watching TV. At that time, Srimati Rajeshwari Dole came to our house and she was watching TV. At that time, accused entered to the said room and told us to give some space. I thought that he wanted to watch TV and so I gave him space. At that time, my deceased husband was holding the remote of the TV. Then accused cut the right hand of my deceased husband with an instrument. At that time, Rituraj Dole and Pitiraj Dole were also present, though they were not examined. I requested the accused to forgive if anything has happened to him. Accused also threatened to cut us along with our sons. He also stated that he is not scared of going to jail, but he will cut us. Then I caught hold of my husband to save him from the further assault by the accused. After that, I took my husband to Dhukuakhana Hospital for his treatment. Accused fled away from the scene. My deceased husband succumbed to his injuries on the way to the hospital. On the date of the incident, my father-in-law gave rupees 65,000 to my deceased husband, which he incurred after selling a pair of buffaloes. The said amount was kept by husband for treatment of my father-in-law. Accused wanted to purchase a bike with that amount. The age of my husband, deceased husband, was more than 25 years at the time of the incident. I lodged FIR before the police on the next day of the incident. Exhibit 1 is the FIR, wherein Exhibit 1 is my signature. Police took the dead body of my deceased husband for postmortem. Cross-examination. Accused used to stay with my father-in-law in a separate house from us. At that time of the incident, my father-in-law was ill and we kept the money for his treatment. The money was kept by my husband. It is not a fact that my husband consumed liquor on the date of the incident. It is not a fact that accused asked my deceased husband as to how much money was gained from selling the buffaloes. And he also told my husband that he would spend the money for the treatment of my father-in-law. It is not a fact that my husband got angry at the suggestions given by the accused. It is not a fact that the instrument which was used at the time of the incident belonged to us. It is not a fact that my husband himself sustained injury in his hand under the influence of liquor and by falling on the karat. It is not a fact that that accused put clothes on the injury of my deceased husband after the incident. It is not a fact that accused did not flee away from the place of incident. It is not a fact that we made him get out of our house. It is not a fact that my deceased husband told the accused that he will not spend the money for the treatment of my father-in-law. It is not a fact that I did not state before police that at the time of the incident, accused came to our TV room and told us to give him sight for watching TV and then gave him sight. I have not seen the karat today in the court. It is not a fact that accused has not committed the alleged incident and we have lodged a false case against him. Now PW2, Rajeshwari Dole. I know the accused person. He is the own younger brother of my late husband. I also know the deceased who used to reside in our village. I reside near the house of the deceased. At this stage, the witness is declared hostile at the prayer of the learned PP Jurhat. Cross-examination by proceeding. It is not a fact that I stated before the police that on 21/5/2018, at about 8 p.m., I went to the house of the deceased Sri Dharmen Dole in order to watch TV. I, along with the accused Sri Dharmen Dole, his wife Srimati Rekha Dole, and their 2 children were watching TV. I could come to know that the father of the accused is ill. I could also come to know that Sri Dharmen Dole incurred some money by selling a pair of buffaloes for the treatment of his ill father. After some time of my stay there, the accused, namely Sri Kolamanu Dole, came to their house and started demanding the money from Sri Dharmen Dole, which he incurred by selling the buffaloes for the treatment of his father. When the deceased refused to give the said money to the accused, he got angry and cut the deceased on his right hand with a weapon which he brought with him. After that, the accused fled away from the scene. Soon after the assault, the wife of the deceased tied the injuries of the deceased with a cloth and took him to the hospital for treatment, but he succumbed to his injuries. It is not a fact that I have stated falsely for the sake of the accused. Cross-examination on behalf of accused. Police did not record my statement. I did not state before police that accused cut his elder deceased brother and fled away from the scene. I did not go to the house of the deceased on the date of the incident. PW3. I know the accused person. He is the own younger brother of my late husband. I also know the deceased who used to reside in our village. Incident took place around 3 months ago.
No, just a minute. He is the younger brother of my late husband means. Brother of my late husband.
Son of
This
late
person is a male.
Fukan Dole, Sri Fukan Dole.
Something appears to be amiss here.
Check the origin.
Itu original hai.
Original is an accident.
No, itu signature আছে তো ইয়াতে।
How can the deceased be PW3's husband? Yes, Miss Zahan, just check it once. You continue.
161 I'm checking.
Hmm.
মোক সোধাত কওঁতে মোৰ মৃত্যু আজি ৰাতিপুৱা হয় মই লগে লগে he is Fukan Dole, son of son of Joy Chandra Dole. He didn't give his relation with the Chandra Dole. Even PW2 same statement
Same
is
statement
there.
is there.
PW2 also. Late husband, he is the younger brother of my.
Something is wrong here.
It is probably a copy paste of PW1.
All right. Let's continue.
I also know that it is
Created before the trial court, sessions court, looks like.
I'll just check from 161 again.
All right. Yes, Mr. Amit, please.
I also know the deceased who used to reside in our village. Incident took place around 3 months ago. People of the village told me about the incident on the next day of the incident. After getting information, I went to the house of the deceased. I found the police and village persons there. I was told by the wife of the deceased that accused killed the deceased. I was told that incident took place on the previous night. I cannot say by what instrument accused cut the deceased. I did not meet the accused person on the spot. Cross-examination on behalf of the accused. I cannot say the name of the person who told me about the incident. I do not have personal knowledge about the incident. The wife of the deceased told me that accused killed the deceased. It is not a fact that accused told me that deceased sustained injury on his person when he went to ask him for the money kept by the deceased after selling the buffaloes. It is not a fact that accused told me later on about the incident. Deceased was not in the habit of consuming excess liquor. The father of the accused is ill. PW4. I know the accused person. He is from our village. I also know the deceased of this case. Dharmen Dole died. There was quarrel between the accused and the deceased about 10 p.m. The assault accused assaulted the deceased. At that time, I was sleeping in my house. In the morning hours, I came to know that deceased has died. I heard that accused has assaulted and caused murder of the deceased. At this stage, witness is declared hostile. Crossed by prosecution. It is not a fact that I did not state before the police that after the night of the incident, I came to know from my wife that Kalamanu Dole has hit Dharmen Dole with an iron saw. I also know that accused Kalamanu Dole was a cruel person, and on the other hand, Dharmen Dole was a simple person. I could also come to know that Dharmen Dole has incurred some money by selling a pair of ox, and he kept that money for the treatment of his father. Accused Kalamanu Dole asked that money from him, and when he denied, he cut the deceased. The deceased sustained severe injury, and out of excessive bleeding, he must have died. It is not a fact that I have deposed falsely for the sake of the accused. Cross-examination on behalf of accused. Police did not meet me. I did not give any statement before the police. I did not state before police as told by learned PP today. I do not have any relation with the accused person. I do not know the cause of quarrel between the accused and the deceased. PW 5. Manjit Dole. I know the accused person. He is from our village. I also know the deceased of this case. Incident took place before 3-4 months. On the date of the incident, I went to the house of one person. I have heard the incident from other people. At this stage, witness is declared hostile. Cross-examination by prosecution. It is not a fact that I did not state before police that accused and deceased are brothers. I came to know that the father of the deceased was ill, and for that reason, deceased Dharmen Dole sold a pair of ox and kept the money with him for the treatment of his father. On 21/5/2015, at about 8 p.m., the accused entered into the house of the deceased and asked for money. When the deceased refused to give him the money, the accused hit him with an iron saw at the right hand of the deceased. The deceased was severely injured, and he succumbed to his injuries in Kuakhana Hospital. The accused fled away from the place after committing the said offense. I do not know where the accused is at present. It is not a fact that I have deposed falsely for the sake of the accused. Cross-examination on behalf of accused. I have not stated before police as told by learned PP today. I cannot say why police took my signature. PW 6. Vishal Dole. I know the accused person. He is from our village. I also know the deceased of this case. He was the brother of accused person. Incident took place less than 1 year ago. At that time, I was at Junai. I came to my village after 2-3 days of the incident. I heard that accused has killed his elder brother. During investigation, police seized one iron saw. Exhibit 2 is the seizure list, wherein Exhibit 2.2 is my signature. Cross-examination on behalf of accused. I do not remember who told me about the incident. Police recorded my statement. It is not a fact that I did not state before police that I heard from villagers that accused has killed the deceased. Police told me that they have seized one article, but I did not see the seized articles. PW 7. I know the accused person. He is the brother of the husband of my sister. Her husband has expired. At the time of the incident, I was having my dinner. There is a river between me and the house of the deceased person. If one shouts from one side of the river, the other person can hear the same from another side. On the day of the incident, after hearing hue and cry, I went to the residence of the deceased. I took the injured to the hospital in an ambulance, but my brother-in-law succumbed to his injuries in the hospital. When I meet my brother-in-law, he was not in a position to speak. I heard accused had killed the deceased. The nearby persons told me about the said fact. Cross-examination on behalf of accused. Police recorded my statement. I did not state before police that my sister and other villagers told me that accused has killed my elder brother. It is not a fact that I have deposed falsely today for the sake of my sister. It is not a fact that accused did not kill the deceased. Deceased was not in the habit of consuming liquor. PW8. Bhavajit Dole. I know the accused person. He is from our village. I also know the deceased of this case. He was the brother of the accused person. My house is at a distance of about 2 kilometers from the place of the incident. On the next day of the incident, I came to know about the incident that deceased has expired. I heard that accused has killed his elder brother. During investigation, police seized some articles which I put my signature, where I put my signature in the seizure list. Exhibit 2 is the seizure list, wherein Exhibit 2(3) is my signature. Cross-examination on behalf of accused. Police recorded my statement. I did not state before police that my wife told me that accused killed his brother. I do not have any personal knowledge about the incident. PW9. He conducted postmortem examination. On 22/5/2018, I was posted at Gormar Civil Hospital as medical and health officer. On that day, as per police requisition in connection with Gormur police requisition dated 22/5/2018, I held autopsy over the dead body of Dharmen Dole, Hindu male aged about 35 years. I found the following: a male dead body of average build with rigor mortis present. Injuries: a deep cut injury over the right arm involving the major vessels. Except this, no other injury is found. More description, detailed description of injury or disease nil. In my opinion, the cause of death is due to coma as a result of shock caused by uncontrollable bleeding from the ante-mortem injury of the deceased. Exhibit 3 is the postmortem report, where Exhibit 3(1) is my signature. The injury might have been caused by sharp object. PW10, IO. On 22/5/2018, I was posted at IC Naya Bazar Patrol Post. On receiving an Azahar from Srimati Rekha Dole, I made GD entry 303/2018 and forwarded the Azahar to Bapukon Moran, OC Jengraimu PS for registration of FIR under Section 302 IPC. Exhibit 1 is the Azahar and Exhibit 1(2) is my signature, and Exhibit 1(3) is the signature of Bapukon Moran, which I identified. I went to the place of occurrence and prepared sketch map. Exhibit 4 is the sketch map, and Exhibit 4(1) is my signature. I interrogated the witness present at the place of occurrence. I took the dead body to Gormur Civil Hospital. The inquest was conducted by Executive Magistrate at Gormur Civil Hospital. The dead body was sent for postmortem. I interrogated the complainant on 22/5/2018. I sent a WT message for apprehending the accused. On 25/5/2018, information was received from Dhemaji PS regarding the presence of the accused at Dhemaji. The accused was apprehended by Junai PS and he was brought to Jengraimu PS. I interrogated the accused and took his statement. As shown by the accused, the weapon of murder was recovered and seized. Exhibit 2 is the seizure list and Exhibit 2(4) is my signature. I recorded the statements of the seizure list. Thereafter, the accused was arrested. The accused and the seizure articles were produced before the court. I collected the postmortem report on 31/5/2018. On finding prima facie material against the accused for commission of the offense, after due investigation, charge sheet was filed against the accused on 31/5/2018, bearing number 18 of 2018. Exhibit 5 is the charge sheet and Exhibit 5(1) is my signature. PW2 Rajeshwari Dole had stated before me that on 21/5/2018 at about 8 p.m. she went to the house of deceased Dharmen Dole in order to watch TV, and she, along with deceased, his wife Srimati Rekha Dole, and their 2 children were watching TV. She could come to know that the father of the accused is ill, and also came to know that Sri Dharmen Dole incurred some money by selling a pair of buffaloes for the treatment of his ill father. After some time of her stay there, the accused, namely Sri Kolamanu Dole, came to their house and started demanding the money from Dharmen Dole, which he incurred by selling the buffaloes for treatment of his father. When the deceased refused to give the said money to the accused, he got angry and cut the deceased on his right hand with a weapon which he brought with him. After that, the accused fled away from the scene. Soon after the assault, the wife of the deceased tied the injuries of the deceased with a cloth and took him to the hospital for his treatment, but he succumbed to his injuries. PW4 Bapukon Dole had stated before me that after the night of the incident, he came to know from his wife that Kolamanu Dole had hit Dharmen Dole with an iron saw. He also knew that accused was a cruel person, and on that day, on the other hand, Dharmen Dole was a simple person. He could come to know that Dharmen Dole has incurred some money by selling a pair of ox, and he kept that money for the treatment of his father. Accused Kolamanu Dole asked that money from him, and when he denied, he cut the deceased. The deceased sustained severe injury, and out of excessive bleeding, he might have died. PW5 Mojid Dole had deposed before me that accused and deceased are brothers, and he came to know that father of the deceased was ill, and for that reason, deceased Dharmen Dole sold a pair of ox and kept the money with him for the treatment of his father. On 21/5/2015, at about 8 p.m., the accused entered into the house of the deceased and asked for the money. When the deceased refused to give him the money, the accused hit him with an iron saw at the right hand of the deceased. The deceased was severely injured, and he succumbed to his injuries at Dhukuakhana Hospital. The accused fled away from the place after committing the said offense. He does not know where the accused is at present. Cross-examination on behalf of accused. I have not seized the dhow which had been mentioned in the Ejahar and charge sheet. I have not seen the original inquest report in the court today. It is not a fact that inquest was not conducted by Executive Magistrate Ajit Kumar Sharma, ACS Revenue Circle Officer. I had not taken statement of Executive Magistrate Ajit Kumar Sharma, ACS Revenue Circle Officer under Section 161 CRPC. I have not stated that the nature of the weapon in the seizure list. I have not mentioned the specific place from where the weapon was seized in the seizure list. I have not mentioned in the seizure list that the weapon was recovered from the accused. I have not seen the seized weapon seized by Exhibit 2 seizure list. I have seen the seized weapon seized by Exhibit 2 seizure list. I have produced the seized weapon before the magistrate. It is not a fact that the weapon was seized from the deceased. It is not a fact that the signature of the seized witnesses were taken in the police station and they are not aware of the nature of the seized weapon. I did not send the seized weapon to Forensic Science Laboratory. I had not taken the statements of Rituraj Dole and Pituraj Dole. It is not a fact that the PW1 Rajeshwari Dole It ought to have been PW2. Not a fact that Rajeshwari Dole had not stated in her 161 CRPC statement before me that she did not go to the house of the deceased on the date of the incident. It is not a fact that I did not record the statement of Rajeshwari Dole. It is not a fact that Rajeshwari Dole did not state in her 161 CRPC statement that the accused had cut his elder deceased brother and fled away from the scene. It is not a fact that I did not meet PW4 Bapukon Dole, and he did not give any statement before me, and did not state what was read over by learned PP in court. It is not a fact that PW4 did not state before me that he did not have any relationship with the accused person. PW5, Manjit had put his signature in the seizure list in my presence. I have not recorded the statement of any doctor at Bhokwakhana Hospital. It is not a fact that I have not investigated the case properly. It is not a fact that the weapon is not recovered by me as shown by the accused. It is not a fact that the accused was not absconding at Dhamaji and came to police station immediately on receipt of information from Jonai PS. His 313 statement was recorded. He denied everything. Now, Lordship, may I turn to the postmortem report that is at page 57.
Yes.
I am placing reliance on page 60, Lordship, column number 5.
233 to comply.
1 minute, 1 minute.
233.
Hmm.
888 the examining case. 888 the examining case. 888 the examining case. We want to use considerance. No. যদি কনভিকশন যদি হয় তাহলে he must be direct
তেনেকে prejudice দেখাব পাৰে না এইটোতো বহুত বস্তু গণ্ডগোল আছে সেশনস কোৰ্টৰ জাজমেন্ট এইবিলাক ৰেক্টিফিকেশন দৰকাৰ আছে Yes,
Page 60, Lordship.
yes.
Because except that deep cut injury over right arm, there are no other injuries. And here the Lordship will find page 5, injury, deep cut injury over right arm, other injuries are absent. Fracture, dislocation, nothing is there.
So PW1 informant is the eyewitness. What is your basic submission, Mr. Amin?
From the record, Lordship, what it appears to me, Lordship, that this is not a case under where, Lordship, the appellant can be convicted under 302. At best, this can be under 304 part 2, Lordship. Because here the prosecution failed to establish that the injury which was caused by the appellant is Lordship, sufficient to cause death in ordinary course. That observation is neither in the medical report nor they have exhibited the weapon of assault. They have proved not proved that weapon of assault. And the injury was caused in the arm. After that, no injury was caused. There was no cruelty shown by the appellant. Only one blow, not in the vital part. Knowledge may be there, but intention was not there.
But there is premeditation. He came with the weapon.
That is disputed, Lordship. Because, Lordship, some witness said, Lordship, because PW1 said, Lordship, that Korat was used. Korat. saw, Korat was used,
Hmm.
and there some says lordship thou. And the prosecution, the investigating of.
Sharp weapon, instrument, thou, karat. The fact of the matter is that he used a sharp weapon to cut off the hand of the deceased.
Lordship.
And that weapon was not lying inside the house, but the accused had brought it. So therefore, when he entered the house,
Lordship.
he definitely came with the intention of causing grievous assault on the victim. So you are saying there is no intent in this case. Why would a person
For
come
the
with a
nature of the
weapon?
injury, lordship, because the intention, if it has to be from the gathered from the circumstances, lordship.
Hmm?
He might have come with that answer, but when he caused the injury, he had not that intention because he had not assaulted in the vital part of the body on the arm, and after one assault he stopped. There was no other assault. Just lordship, may I take your lordship to section 300, lordship?
Yes, let us see. And we'll also see 326. No, IPC.
IPC 300, lordship.
Hmm. Yes.
IPC 300 murder. Except in the case herein after accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death of the person to whom the harm is caused. Thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. So they have to prove this thirdly, because bodily injury is there, I admit that part. So they have to prove that it is sufficient to cause death in the ordinary course of nature. That is, they have to
No,
prove.
chopping off an organ.
No, that
a
is not
limb.
chopped off, that part is
What
not
proof
there.
is required? As judges, we can't assess that.
No, here it is a deep cut injury. Chopped off is not there, lordship. Chopping off is not there. Just I am taking a lordship again to the postmortem report.
Hmm.
Page 58, your lordship will find.
Page 58.
58.
Yes.
Column number 2, wound, position and character. A deep cut injury over the right arm involving the major vessels.
All right. Hmm.
So to make out a case under thirdly lordship, they have to show that it is sufficient in the ordinary course of nature to cause death.
Now, what about the second condition of 300?
If it is done with the intention of causing such bodily injury as the offender knows is to be likely to cause death of the person. Here also their word is likely to be cause death. If lordship someone hits in the hand, nobody lordship expect that he will die, because otherwise lordship he would have caused in the head or neck something or some vital parts.
Hmm.
If it is in the head or neck, then this second part will come in my humble submission, Lordship.
All right, what else? What else?
And second, then therefore, Lordship, the exception 4
Hmm,
of section 300.
yes,
Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner.
no, but premeditation, at least he came inside with whatever weapon he used.
Lordship.
That he did not pick up from the house. He came, brought it along with him. That part is established.
That is there.
And it was a sharp weapon.
Lordship.
So you mean to say a person comes inside the house with a weapon, picks up a quarrel and immediately strikes, causing grievous injury. He never had any premeditation.
So that premeditation, Lordship, my submission to your Lordship is that premeditation has to be gathered for intention, and premeditation has to be seen from the circumstances.
Hmm.
Here, your Lordship will see that he had brought the dove with him, he came there. There was heated argument, and thereafter he caused injury only to the hand, Lordship, arm. All the circumstances, Lordship. If he had premeditation, he would have caused in the neck or vital part of the body.
All right. Hmm.
And quarrel part is admitted by the PWs and even by the learned crime code also, that your Lordship will find at page 51 of the paper book.
Page 51.
Page 51, Lordship. Paragraph
Yes.
28.
Paragraph?
28.
Yes.
In the case in hand, as already discussed, following an altercation between the accused person and his brother, since deceased, the accused person cut the right hand of his brother, since deceased, with a sharp instrument. As per the medical evidence on record, the cause of death is due to coma as a result of shock caused by uncontrollable bleeding from the antemortem injury of the deceased. The intention of the accused, as it is found from his conduct, was such that the accused person, after committing the act, knew that it was so eminently dangerous that it must be, in all probability, cause death or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. This being so, in my considered opinion, it is held that the offense committed by the accused persons comes within the purview of section 302 of IPC. And regarding premeditation, Lordship, there was no prior quarrel between the deceased and the appellant, that he will know that he will refuse to pay the money and he will assault him.
Hmm.
So that is not the case of the prosecution. Prior to that, there was no quarrel. It is suddenly on there when he refused to pay, then quarrel started, Lordship. This is my humble prayer, Lordship.
So do you have any citation, any authority on similar lines to back up your argument that this is a fit case for conversion?
That I have. After some time, I will produce that.
All right.
I have few judgments where 302 is converted to 326 as well as
Oh, yes, we wanted to just read 326.
324.
Hmm.
Three 26, two cases that I have there, what had happened is, death was not due to the direct result of the assault. Moreover, the person died after months. That was 92 supplementary 2. This is not the case here.
Hmm.
Second, I have 197.67 where one hit was on the head and the other few injuries were by the gunshots and those were on legs. So Supreme Court said, if he had any intention to kill, he would have shot on the head. So in that case also 326 it was converted. As far as culpable homicide, he is not arguing on that, and it was committed by the accused is also admitted fact. Now, as far as conversion, 304, in order to come within the exceptions, of course, the wife had not stated the full story, it seems, in the trial court. She said that he came, she did not say he came with the weapon or the instrument. She simply said he came and he wanted some space as we were all watching television. And we thought he wants to watch television. We had given him a place to sit. He sat beside my husband and he had cut his hand all of a sudden. Quarrel part also she did not say, or whether she came with the instrument, that also she did not say. 161 I have checked, she said he came with the instrument, he quarreled, and thereafter this thing happened. Other than the 4 witnesses, the deceased, the accused, the wife and Rajeshwari turned hostile. None were there. So she is the only, others have all heard.
That's right. So where is the evidence to conclude that there was a quarrel which preceded? Where is the evidence?
Quarrel, wife did not say. The FIR is there. FIR, the quarrel part is there. That is again not substantive piece, but quarrel part is there in the FIR. And 161 there is, it cannot be again taken. Other witnesses.
This fact mentioned in the FIR may not be sufficient to convict the accused, but it can be used to grant some benefit to the accused that there was in fact a quarrel, even if the PW1 did not depose.
And she said that initially after the cut, she asked forgiveness from the accused. So there was something. She did not say, she did not reveal before the trial court.
No, she said that this is to prevent further assault. She said if we have done any mistake,
Forgive us.
forgive us. That is okay, because obviously if somebody is armed with a sharp weapon and he started hacking the husband, she was beseeching for mercy. That's the whole
That
idea.
can be interpreted.
That is okay. But the fact of the matter is, this witness, her evidence is very scanty. It does not disclose the whole facts, obviously, as you said, and she was very miserly with her statements. Therefore, a few things are left to speculation. But the fact of the matter is, she has seen the occurrence. This witness has remained intact. And she has proved that it is the accused who has come and hacked her husband with a sharp weapon, cut his arms, deep cut. And that is the cause of death due to coma and shock.
Due to excessive bleeding.
Excessive bleeding. Yes.
As far as cutting offense committed by the accused, PW1 is enough evidence. One oral witness will be enough, and here there is PW1. But as far as bringing it within the exceptions, whether there was a quarrel, because she did not say Rajeshwari turned hostile, PW3 did not say anything. He simply said, wife of deceased said, this will be a res gesta evidence. Then quarrel, of course, PW4 had said. Lordship will see PW4. That quarrel
So,
part.
in any case, this is not a case of acquittal.
This is not a case of acquittal.
That's for sure.
But yes, but what will be the punishment? PW4, of course, had said in his examination chief, there was a quarrel between accused and a deceased. And he is the Bapukon Dole, I know that this is, there was a quarrel. This is a hearsay. He was not there at the place of occurrence.
No,
I
none of
was-
these hostile witnesses actually saw anything.
Yes,
So they were turned, they were declared hostile because they just did not support their statement, which was allegedly recorded by the IO.
Hmm.
IO proved these statements, but they say they have never recorded statement
Yes.
before the IO. For
but
whatever
statements are there.
statements are there. So these witnesses were not telling the truth, obviously,
Mhm.
they were declared as hostile. That's understandable. But even without their evidence, the
Hmm.
prosecution case
Yes.
we established. So only question here is whether it will be a case of 302
Hmm.
IPC looks doubtful,
Hmm.
whether it will be a 326 or a 304 part 2 as he is suggesting. That's the only area of argument. We would
So-
like to have some decisions. Of course, these are very well settled areas of law. But
Single
even
blow,
then, to write out a judgment, we would need.
single blow 304, it can be converted. I have those decisions. This is a case of single blow again. Not on the vital part. Ranbir case is there. Ranbir lordship can see once, not on the vital part and single blow.
So can you give us 1 or 2 judgments by 12?
Lordship.
Lordship.
All right.
I will place that Birsha Singh judgment. It is Birsha Singh judgment, Lordship. Here it is clearly said whether it is 302 or 304 that guidelines, some parameters are given in that case. Birsha Singh, I will place that judgment.
Right, you get it at 12, we'll dictate the
Lordship.
judgment in the open court.
Lordship.
At 12, we'll dictate.
Lordship.
Anything else you want to say on the
In
merit?
my humble submission, not 304B or 3041, 326 it can be converted since those exceptions will not come. Provocation also cannot come because it has to be sudden.
Looks like it is a case of 326.
326.
That I will answer to Lordship. Because in my
At
humble
2,
sub-
not at 2.
No, no,
12.
at 12, Lordship. At 12 I will answer.
These two judgment I have, 326.
Because I found some
92.
one judgment, Lordship, where person died, either it has to be 302 or 304, but it cannot be 326. I have found one, I will place that.
But these two judgments have already said their date.
All murder, all murder. So 326.
I don't know. What to treat as a number course as Supreme Court, dead case.
But death case, no.
Actually,
No, no. 326 is during memorial. The person doesn't die.
Counsel judgment. Birsha Singh Amul Ranbir to us. Don't have.
Miss Jahan, tell us one thing.
Hmm.
The person has died ultimately due to the injury, excessive bleeding, coma, whatever you say. And this happened almost immediately after he was sent to the hospital. Maybe if the medical care attention would have been better, maybe. But since he has died, it can't be a case of 326 only.
But those cases, Supreme Court has converted in death cases.
Where are those judgments? Then
This is 92 supplementary 2 SSC and 96-7.
do you have the copies?
I don't have the copies. I can send it by email.
No, then we will send you our judgment by email after 1 year.
92 supplementary 2 and 96-7. At 12 o'clock, as well, I'll also
Alright.
do those.
12 o'clock, give us those judgments.
Lodge.
We want some clarity on these aspects. Yes, but we'll finish it off today itself. Because it's on a short point, whether it should be a 226 or 304. Because there is a death in this case.
There is a
Person
death.
has died.
Ah.
And that death is not a remote occurrence,
Not a remote.
but is
occurrence.
immediately relatable to the incident.
The wife said on the way to the hospital, he died. So perhaps they took him little late. And they, by
But
that
he
time,
died on the same day.
12 o'clock, midnight.
Correct. So this injury is relatable to his death. That goes without saying.
But then because of the length of the time that he was taken to the hospital, There was excessive bleeding. Had he been taken immediately,
Hmm.
perhaps he would not
All
have
right,
died.
12. Yes, next.
Lordship.
Yes, Mrs. Shamu, which is your case?
My lord, that item 2, my lord.
Yes, what do you want in this?
My lord, some gray areas that there, if lordship pleases, my lord, give some time, my lord, I will meet this man. And we take some instruction, and I have seen the LCR also right now.
What is the gray area?
Father raped his own daughter.
That is a very serious issue, my lord.
Hmm.
And last night when I was reading, it looks apparently that it's an open and shut case.
Hmm.
He should be convicted.
Hmm.
He was given RI for life.
Hmm.
But the person, the daughter who alleged this allegation
Hmm.
that she was raped by her father.
This is not a, you are not the amicus here.
I am a maker. Legal aid, my lord. Lordship appointed. my lord.
Yes.
So, my
So
lord,
we'll
only
adjourn
one-
it for,
adjourn it for today, my lord. Lordship, just only one favor, my lord. If lordship passes an order, and DLSA persons gives me an opportunity to meet the.
first of all, as judges and court, we don't do any favor to anyone. So there is no question of doing any favor to you. That or direction, can it be passed that he should be allowed to meet the accused?
I have not come across, I mean.
You can make a request. That's all we'll say. If a request is
Yeah,
made,
that's
then
Court allowed,
that may be considered as per the established procedure.
isn't it?
Otherwise, you have to convince us that this kind of
There is
an
no
order.
harm, my lord. I am.
You saying will not do, what the law says will matter.
There is no impediment passing an order that if I can, if I am a counsel appointed by the court
Hmm.
to give the legal aid to these persons. And if I want some instructions from the accused, and I'm just asking for praying for a piece of paper that giving the DLSA persons or our committee.
All right, you request the Assam State Legal Service Authority to facilitate such visit. We'll ask them to consider.
Man,
That's all.
that will depend.
Mr. A.C. Chamua, learned counsel appearing for the appellant. This is item 2.
Legal aid
Submits that legal aid counsel appearing for the appellant in this case submits that after going through the papers, he finds there are some doubts as regards the allegation brought against the appellant stroke convict, and therefore he requests for an order from this court allowing him to meet the appellant who is housed in the jail at district jail at Gifu.
Jorhat. No.
Karbi Anglong,
Karbi Anglong was-
Gifu.
That's right.
And
Just sitting on.
jail in the district of Karbi Anglong. Full stop. After hearing Mr. Chamwa, we find that he is basically seeking adjournment for 3 weeks so as to meet the appellant and make submissions before this court. Ms. S. Jahan, learned APP Assam, is present before the court. Taking note of the request made by the learned legal aid counsel, we permit him to make an application, make a request to the jail authorities to be routed to the Assam State Legal Service Authority for meeting the appellant. First, if such a request is made, the same may be considered by the concerned authorities. Let this appeal be listed again after 4 weeks.
Well, a copy of this order.
Copy of this order be furnished to Mr. Chamwa. Yes,
Honorable.
yes, next matter.
Item 8. 8.
My lord.
Yes,
My lord, this is a life imprisonment convict under section 30234 IPC.
Mm.
And the FIR, terrorist, my lord, is in
circumstantial evidence.
circumstantial evidence, no eyewitness, my lord. Only the main basis is the dying declaration. Except dying declaration, no evidence. Only his younger brother stated he also made a complaint in the
police station, and he stated each and everything.
Hmm.
But whatever stated in the court, that is first time that were not stated before the IO. So many contradiction, omission, and improvement
Hmm.
in regard to PW1.
Let us see the Ezahar once.
And dying declaration suffers from so many infirmities.
Where is the Ezahar?
My lord,
Ezahar.
my lord, in book, in page number, paper book, page number, my lord, 1. The main details in page number 5, my lord. Sir, humble submission is that it is not. It has been almost 1 year since my elder sister Arati Talukdar married with one accused number 1. Now she is 9 months pregnant. At around 9:30 p.m. on 22/1/2001, the aforesaid accused persons had an argument with my elder sister of her dowry, and they in a body set her ablaze by pouring kerosene on her body. On getting information about the incident, people surrounded the accused, and after recovering my sister in an unconscious state, they informed us. I came to know that the accused number 2 had an ill intention of cohabitation with my elder sister. Now my elder sister has been admitted to Guwahati Medical College, and she is in unconscious state.
Hmm.
My lord.
Where is the postmortem report?
Postmortem report 79, page number 79 in paper book.
All right, let us see the findings of the trial court. Which page?
Unlisted. Hmm. 51, page number from 51. And
Read from 56.
52, my lord. Investigation
56.
56. In reply, number 12. Analysis evidence on record.
Dying declaration recorded by the doctor.
by doctor. No magistrate, no. witness. No in-case report also provided. No in-case report exhibited.
The doctor who recorded the dying declaration has been examined.
Yes.
Examine.
All right.
Exhibit.
All right, what we'll do is, Mr. Pandit, there is another matter, 12 will sit and deliver the judgment. After that, we'll take up your
Second up.
case. Second up,
Second up.
second up. You come in the second up.
Second.
Today, there is some reference also.
Yes, 315.
After this judgment, then we'll take up his matter
Gotcha.
today itself. Yes. We are giving you 10-15 minutes time so that you can,
Yes,
Right.
I can prepare.
otherwise we will have to push it again by a day, which we don't want to do it. Let's finish off this matter.
Gotcha.
Just give us that judgment.
Huh.
Yes.
Paragraph 8, Lordship. 8 onwards.
Yes, let us read it.
Lordship. The learned session judge found that the appellant was 21 or 22 years old and said, when the common object of the assembly seems to have been to cause grievous hurts only, I do not suppose Birsa Singh actually had the intention to cause the death of Kasem Singh. But by the rash and silly act, he gave a rather forceful blow, which ultimately caused his death. Peritonitis also supervened and that hastened the death of Khem Singh. But for that, Khem Singh may perhaps not have died and may have lived a little longer. Based on those facts, he said that the case fell under section 300 thirdly, and so he convicted under section 302 of the Indian Penal Code. The learned High Court judges considered that the whole affair was sudden and occurred on a chance meeting, but they accepted the finding that the appellant inflicted the injury on Khem Singh and accepted the medical testimony that blow was a fatal one. It was argued with much circumlocution that the facts set out above do not disclose an offense of murder because the prosecution has not proved that there was an intention to inflict a bodily injury that was sufficient to cause death in the ordinary course of nature. Section 300 thirdly was quoted. If it was done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. It was said that the intention that the section requires must be related not only to the bodily injury inflicted, but also to the clause, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. It is a favorite argument of this in this kind of case, but is fallacious. If there is an intention to inflict an injury that is sufficient to cause death in the ordinary course of nature, then the intention is to kill, and in that event, the thirdly would be unnecessary because the act would fall under the first part of the section, namely, if the act by which the death is caused is done with the intention of causing death. In our opinion, the two clauses are disjunctive and separate. The first is subjective of the offender. If it is done with the intention of causing bodily injury to any person, it must, of course, first be found that bodily injury was caused and the nature of the injury must be established. That is to say, whether the injury is on the leg or the arm or the stomach, how deep it penetrated, whether any vital organs were cut, or so forth. These are purely objective facts and leave no room for inference or deduction. To that extent, the inquiry is objective. But when it comes to the question of intention, that is subjective to the offender, and it must be proved that he had an intention to cause the bodily injury as is found to be present. Once it is found, the inquiry shifts to the next clause, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. The first part of this is deceptive of the earlier part of the section, namely the first part, namely the infliction of bodily injury with the intention to inflict it. That is to say, if the circumstances justify an inference that a man's intention was only to inflict a blow on the lower part of the leg or some lesser blow, and it can be shown that the blow landed on the region of the heart by accident, then though an injury to the blow to the heart is shown to be present, the intention to inflict an injury in that region or of that nature is not proved. In that case, the first part of the clause does not come into play. But once it is proved that there was an intention to inflict the injury that is found to be present, then the earlier part of the clause we are now examining, and the bodily injury intended to be inflicted, is merely deceptive. All it means is that it is not enough to prove that the injury found to be present is sufficient to cause death in the ordinary course of nature. It must be in addition be shown that the injury is of the kind that falls within the earlier clause, namely that the injury found to be present was the injury that was intended to be inflicted. Whether it was sufficient to cause death in the ordinary course of nature is a matter of inference or deduction from the proved facts, but about the nature of the injury and has nothing to do with the question of intention. In considering whether the intention was to inflict the injury found to have been inflicted, the inquiry necessarily proceeds on broad lines, as, for example, whether there was an intention to strike at a vital or a dangerous spot, and whether with sufficient force or cause the kind of injury found to have been inflicted. It is, of course, not necessary to inquire into every last detail, as, for instance, whether the prisoner intended to have the balls fall out, or whether the intended to penetrate the liver or the kidneys or the heart. Otherwise, a man who has no knowledge of anatomy could never be convicted for if he does not know that there is a heart or a kidney or bowels. He cannot be said to have intended to injure them. Of course, that is not the kind of inquiry. It is broad-based and simple and based on common sense. The kind of inquiry that 12 good men and true could readily appreciate and understand. To put it shortly, the prosecution must prove the following facts before it can bring a case under section 300. First, it must establish quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved. These are purely objective investigation. Thirdly, it must be proved that there was an intention to inflict that particular bodily injury. That is to say, that it was not accidental or unintentional, or that some other kind of injury was intended. Once these three elements are proved to be present, the inquiry proceeds further. And fourthly, it must be proved that the injury of the type just described, made up of the three elements set out above, is sufficient to cause death in the ordinary course of nature. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. Once these four elements are established by the prosecution, and of course the burden is on the prosecution throughout. The offense is murder under section 330. It does not matter that there was no intention to cause death. It does not matter that there was no intention even to cause any injury of that kind, that is sufficient to cause death in the ordinary course of nature. Not that there is any real distinction between the two. It does not even matter that there is no knowledge that an act of that kind will be likely to cause death. Once the intention to cause the bodily injury actually found to be present is proved, the rest of the inquiry is purely objective, and the only question is whether, as a matter of purely objective inference, the injury is sufficient in the ordinary course of nature to cause death. No one has a license to run around inflicting injuries that are sufficient to cause death in the ordinary course of nature and claim that they are not guilty of murder. If they inflict injuries of that kind, they must face the consequences, and they can only escape if it can be shown or reasonably deducted that the injury was accidental or otherwise unintentional. We are referred to a decision of Lord Godin, where the learned Chief Justice says that where a particular intent must be laid and charged, that particular intent must be proved. Of course, it must be proved by the prosecution. The only question here is, what is the extent and nature of the intent that Section 300 thirdly requires, and how it is to be proved? The learned counsel for the appellant next relied on the passage where the learned Chief Justice says that if on the totality of the evidence there is room for more than one view as to the intent of the prisoner, the jury should be directed that it is for the prosecution to prove the intent to the jury's satisfaction. And if on a review of the whole evidence, they either think that the intent did not exist or they are left in doubt as to the intent, the prisoner is entitled to be acquitted. We agree that that is also the law in law, but so is this. We quote a few sentences earlier from same learned judgment. No doubt, if the prosecution proves an act of natural consequences of which would be a certain result and no evidence of or explanation is given, then a jury may, on a proper direction, find that the prisoner is guilty of doing the act with the intent alleged. This is exactly the position here. No evidence or explanation is given about why the appellant thrust a spear into the abdomen of the deceased with such force that it penetrates the bowel and 3 coils of the intestine came out of the wound, and that digest food.
Mr. Ahmed, why are you relying on this judgment? It goes against you.
No, here, Lordship, paragraph 14, 15, 16, 17, Lordship. These, Lordship, here guidelines are given when it comes under 300 thirdly. Here, your Lordship will find, just I am reading paragraph 19.
Yes.
Fourthly, it must be proved that injury of such type, just described, made up of the 3 elements set out above, is sufficient to cause death in the ordinary course of nature. Here, there is no evidence that this injury is sufficient to cause death of the deceased. Because as I have pointed out before, Lordship, earlier, that section 300 has 4 parts. To make out a case under section 302, the prosecution has to prove that either of the 4 ingredients. Then only section 3 murder can be attributed to any accused, Lordship. And in my case, falls under 300 subclause 3, because bodily injury is there and he died due to that bodily injury. Now, whether that bodily injury is sufficient to cause death of the deceased, they have to prove that aspect to convict the appellant under section 302, Lordship. If that is not there, then my case authority will go to next section, that is 304, culpable homicide, not amounting to murder.
Yes.
And as I have already placed before Lordship the postmortem report and the evidence of doctor, there is not a single whisper about whether this injury is sufficient to cause death of the deceased or not. And apart from that, there is the prosecution side has withheld the inquest report here. inquest report is relevant here to ascertain the time of death. That is not proved by the prosecution. When the deceased died, at what time, that is not proved. So whether immediately after the incident he died due to the injury or due to non-getting of medical treatment, he died subsequently. That is silent here.
So according to you, it's a case of 304 part 2.
Part 2. And already he is in custody since 2018, so period of detention.
As far as converting to 326 is concerned, we just like to place two decisions. Of course, I'm not very happy with the decisions, but then it lays down on.
If you're not happy, then ignore it.
No, I'll just tell the facts then. 92 supplementary 2. Here what happened, Devraj? Here the death was not because of the direct result of the injury. Here what happened in Devraj case, there was one injury on the head and other injuries were by the firearm and which were on legs. And the person died because of various surgeries done after he was admitted. And then he died after a month or so. And so the Supreme Court said, no, this will not be a case of 302. This will be a case of 326. Lordship will see only that last paragraph, very short judgment. Not take your Lordship's time. The last paragraph. The last paragraph of
Man could tell.
92 supplementary 2. 81.
So
The
in
death
this
was
case, the deceased died after almost 1.5
1
months.
month. And because of amputation of the arm, he had to die. Because of the surgeries, they had to amputate the arm. So he died and saying that no. But in that cases, 326 is converted. In the present case, had he been taken immediately? Of course, because I'm reading so many judgments, I got confused. This is the case where one injury was on head and the other injuries were on legs, and it was also converted to 326. One paragraph. It's very small. The last paragraph. Had there been the intention, he would have shot him on his head, they said. And one, if Lordship might know this, this is Justice Bopanna's judgment, 2019-6. Here there was a single blow, and by the blunt side of the weapon, on the head, of course, and that was converted to 304 part 1. High Court converted it to part 2. That was interfered with, and Supreme Court converted it to part 1, saying that there is an intention because the head vital part was considered.
But here it is.
Here, of course, here only arm. Because I'm showing this because of the single blow. This is the last paragraph. This is the facts. Kali Charan.
Okay, if we convert it, you want to argue anything on this sentence?
And he wanted 65,000. He wanted to purchase a bike instead of treating the father. 7 years, 8 years, I'll say. This is my humble submission. Whatever.
But Mr. Ahmed, yes,
My suggestion is also maximum 10 years under section 30204 part.
we'll make it 8 years and finish it off.
And he has been inside since the day of his arrest.
And his own ailing father is also there, also considering that way.
Right on. He has been unruly also. Heard Mr. Ahmed, learned counsel appearing, learned amicus curiae appearing for the appellant. Also heard Miss S. Chauhan, learned Assam appearing for the state. First up, his appeal from jail is directed against the judgment and order dated live streaming of court.
Hello, then add that may be fixed.
Huh?
Then add that may be
What
fixed.
date? It is in the part 2 list.
No, part 1.
Part one.
Supplementary.
Part 1.
Part.
So what to do if this is a ground and the counsel is unable to come to court, his father is expired.
Yes, then
What option do we have?
I have
Yes.
learned that the father of the informant,
no, the Himanku's father expired.
then it may be considered. Then it may be considered.
If it was father of informant, then we would not
No,
have
that
been
is
bothered.
not. In fact, the junior mother, Himanku's father.
I
He-
have learned from him. that,
Mr. Himanku
informants-
came to court.
Informants.
Then he was informed his father had a heart attack. He rushed, and his junior said to both of us that he expired.
It will be very uncourteous to go ahead with the, at least after we have learned about this. We'll have it next week. By that time,
Yes.
One that may be fixed, my lord.
but
Otherwise,
will he be able to
It
come
will be-
next week if his father is
Again,
expired?
Shraddha and everything. over.
Probably not.
2 weeks.
All the 7 days. He will have Shraddha and all these things. Minimum 11
2
days.
weeks would be better, I believe.
but so far my knowledge was, he told the informant's father. Informant's father.
No, not informant's father, Himanku's
Sure.
father. One, Himanku's father.
Oh, now don't ask us to get into this.
Yes.
I had Mr. S. C. Pandit, learned counsel for the appellant, also had Ms. S. Jahan, learned APP Assam appearing for the state. This matter was fixed today for final hearing. But as the appeal was called up, we are informed that the father of the learned counsel, learned legal aid counsel appearing for the informant has expired this morning due to a heart attack, for which he had to rush back home. Full stop. Since
15
the,
days. After
since
15 days.
since the legal aid counsel was appointed by an order of this court, and considering the ground on which the legal aid counsel is absent today, we deem it appropriate to adjourn the hearing of this appeal. Full stop. So appeal, so as to give him an opportunity to appear in this matter. Full stop. Consequently, this matter is directed to be listed again after 2 weeks
6, maybe 6, 7.
as a fixed item. Yes, after 2 weeks. Yes. Any other matters?
Item 9. Item 9.
Maybe his lordship. But I for suspension of sentence and paying for release then to go on bail, my lord. And the FIR lodged, my lord, against the 7 numbers of accused, my lord. Among these 7 numbers of accused, my lord, 4 numbers of accused already acquitted conduct. I allow with that hearing
You go and send.
and main appeal paying for state effect and passing the into judgment dated. 11
Lordship is taking up the main appeal, my lord.
Main.
No, no,
It
this
has
is
come
the
up for
earlier has
hearing.
been listed. It has come for hearing. The main appeal has.
Main appeal is for comfort hearing, but till date, I also pending till date.
Today, are you ready to argue the main?
Yes,
appeal?
yes, madam.
Achha, then let us have the paper book. Let us see.
Page 4 to 6 is the FIR, my lord. Azahar, my lord. Dated 28/9/2009, my lord. The Azahar was lost against Karimul, appellant number 1, Maimuddin, appellant number 2, Kamala, appellant number 3, and rest of Usman, Noor Hussain, Arman, and Surman are acquitted from the case, my lord. Page 5, my lord. I have the honor to state that it has been about 3 years since the marriage of my niece Hafiza Khatun with accused number 1. She had been being subjected to physical and mental torture in demand of dowry since after the marriage. Accused number 1 has remarried under the instigation of ill advice of accused number 2, 3, 4, 5, and 6, 6 and 7. At about 3 a.m. On 27/8/2009, accused number 6 came to the courtyard of my house and saying that the child of my daughter, that is my grandchild, was ill. He left the house in Iran. Immediately, my elder brother, Abdul Rahim, that means, and a sister-in-law went to the house of the accused and found that the accused person had killed my niece Hafiza Khatun and left her body on the road in between the house of accused number 1 and accused number 6. The accused persons in a body killed my niece and left her body on the road. The accused number 1 and 6 are the two houses. In between the two accused number 1 and 6, there is one pond, my lord. In the time of Rosa Ramzan, my lord, when at time 3, my lord, the deceased went to bring the message fire from the reported house, from the house of accused number 6. And perhaps, my lord, at 3 a.m., my lord, that occurrence was took place and she was asleep and fell down. VDB of the village, my lord, informed to the police that the dead body was drowning on the pond, my lord. And only on suspected and presumption, my lord, the accused appellant were sentencing.
Right, we'll continue after lunch. We'll continue at 2.
Under section 498A, 304B, and 34 IPC, dated 29/8/2009, and charges also claimed on the same section. And sentencing them accused under section 302 that was converted to the 302 and imprisoned them for life and fine of rupees 10,000, and in default another 6 months, arrive for 6 months. My lord, PW1, page 10, my lord. On oath, my lord, may I read, my lord? I know the accused person at about 3 a.m. on 24/4/2007, the incident took place as it is a fasting day of Ramadan. We had our meal at 3 a.m. At that time, 2 persons came to my residence and informed that Kohinoor, the daughter of my nephew Hafiza, had died. Hearing the information, I sent my elder brother Abdul Rahim Huya and my sister-in-law Kamala to the residence of Hafiza. On reaching there, they saw the Hafiza had died. Her daughter did not die. When my elder brother informed me, immediately went there and saw that Hafiza was lying dead on the bank of the pond near her residence. I saw injury mark on Hafiza's neck and her person. Moreover, I saw that blood was oozing out. but I did not meet Hafiza, husband, father-in-law, mother-in-law, they fled away. Then we assembled the villagers and informed the police. At about 2 years ago, from the incident, I socially gave away in marriage my niece to accused Karimul Islam, son of accused Maimuddin, is since organized of marriage. Hafiza was tortured by the in-laws, family demanding dowry. Sometimes Hafiza told us about the assault she was facing for dowry and coming to our house, accused Karimul demanded dowry. We tried our best to fulfill their demand in connection with the case. We lost Ezahar in the PS. Later on, police came and investigated the matter. Police held the inquest on the dead body of Hafiza. The accused killed my niece Hafiza just for dowry. There is no doubt about it. Exhibit 1 is the Ezahar lost by me, and exhibit 1 is my signature. And enclosed mallet on the day of incident. In the morning, I went to the residence of the accused person. After going there, I informed the police, and at about 10 a.m., police arrived at the PO from Kolgasia. Yes, there were staff along with the police officer. On that place, they found the dead body and held the inquest on the dead body. Police questioned the witnesses. After the police left at 2 p.m. on the same day, going to the Kolgasia, yes, I lost an Ezahar in the connection with the incident. After lodging of the Ezahar, police did not question me, but police questioned me on the PO. At first, I informed the police about the incident over phone and also sent a person to convey the information. Accused Kamila Khatun and Karimul Islam live in the family of the accused Noimuddin. They live as joint family. Accused Osman, Nur Hussain, Arman, and Surman are belong to separate families. Their houses are separate. There is no pond at our residence. Mora Nodi is situated at about distance of 1 kilometer from our residence. The deceased Hafiza was grown up living with us since childhood. When Hafiza was young, I saw her swimming in the pond. We had not lost her in the Kolgasia PS regarding torturing Hafiza for demanding dowry, and we had not lost any similar case in the court. In the exhibit 1, that is Ezahar, I have not mentioned the date of demand for dowry and the amount of dowry demand. It is not a fact that it is not mentioned in my Ezahar that on the day of incident in the night, 2 persons arrived at our residence and informed that Hafiza's daughter Kohinoor had died. It is not a fact that it is not mentioned in my Ezahar that on the day of the incident in the night at about 3 a.m. in the courtyard of my resident Arman Ali informed about the illness of niece Hafiza. And thereafter he left. Moreover, it is not written on the Ezahar exhibit 1 about seeing the injuries on the body and neck of the deceased Hafiza and the oozing out of blood. No extrajudicial trial was held in the village for demand of dowry from Hafiza by the accused person. On the day of incident, Maimuddin and Kamila Khatun could not be arrested. It is not mentioned in my Ezahar that the accused persons fled away from the PO after executing the crime. It is not mentioned in the Ezahar that after the marriage, Karimul went to our residence and demanded money for dowry. At the time of incident, Noimuddin's daughter Eliza was also present. She was about 9 years old at that time. It is not a fact that I did not state before the police that in the night itself, two persons came to our residence and informed about the death of Hafiza's daughter Kohinoor. I did not state before the police about seeing injury on the neck and persons of the deceased Hafiza about oozing out blood. It is not a fact that I did not state before the police that going to the residence of Hafiza, I did not meet anybody and I did not tell about their being away. It is a fact that I settled the dispute of dowry demand between Hafiza and Karimul Islam by holding a trial for several times. It is not a fact that I did not state before the police that accused Karimul went to our house and demanded dowry. It is not a fact that I stated before the police that I suspect that Hafiza was murdered by the accused person. I did not witness the incident. It is not a fact that I falsely stated that accused Karimul went to our house to demand dowry. That I saw injury on the body of the deceased Hafiza. It is not a fact that I falsely stated before the police and Hafiza was murdered. All the neighbors of the accused Karimul know that Hafiza was tortured for demanding dowry. Sometimes the accused Karimul works as a vehicle worker. On the day of the incident, accused Karimul was present in his residence. When I reached the PO, I did not see accused Karimul. Appellant number 1, madam. Later on, at about 9 AM, accused Karimul suddenly arrived at the PO. But I got to know from Hafiza that on the previous day, accused Karimul was present in his residence.
1
Yeah.
minute, 1 minute.
Madam.
My learned brother is feeling unwell, so we will rise.
Fine.
Tomorrow?